morning, everybody, and welcome on behalf of the CIB Compliance Department and our guest speakers. I'd like to welcome you all to our morning session. We'll be covering some extremely interesting topics this morning. RDR, POPI, PPR, fit and proper, and then a general legislative update. Geez, that was quite a mouthful. There will be a test afterwards in the back. Just watching people sign in, I trust everybody has signed in terms of their CPD points. Just a lot of people in the room I'm doing business with for a long time, and I've just noticed that the font on the sign-in register gets a bit smaller. People are putting on glasses now. It's just a sign of the times, eh? I'm sure we can all admit that there's a lot going on in our industry at the moment. And whilst I've been having many discussions with brokers over the last few months on where the industry is going, there is a feeling that the short-term industry as a whole is being over-regulated. But unfortunately, change is something we will all need to embrace to survive. I trust you will sit back, relax, and enjoy this morning's session with us. A Q&A session will be held after all the speakers have completed, so I'm going to ask you to hold your questions until the end. We have got a jam-packed session this morning. Venue is non-smoking, so please, in terms of smoking will happen outside. We will break it around 11 o'clock for some refreshments and tea and coffee. Bathrooms, gents just out to the left and ladies around the corner to the left. And we will look at finishing up around about 1 o'clock, time permitting. Any questions? Feather? Okay, without further ado, I'd like to welcome our first speaker. The introduction of Suzette Olivier. Suzette is currently employed at Guardrisk. Prior to her appointment as Executive Governance and Regulatory Affairs, she was a director and shareholder of an underwriting manager, as well as the general manager, legal, at the South African Insurance Association, responsible for providing strategic direction on legal-related issues, including, but not limited to, insurance regulation, treating customers fairly, solvency assessment, and management. She commenced employment at Guardrisk in March 2015 and is currently the public officer for 5 insurance licenses in the group, comprising both life and non-life licenses. During her tenure, she was also the appointed head of compliance. She holds both a BLC and an LLB degree and is an admitted advocate. She is also a director of the Compliance Institute of South Africa and an alternate director of the SAIA board. In July 2014, she was awarded the Cover Award for Excellence in service to the short-term insurance. Her motto in life is to do things that make you happy within the confines of the legal system. You may also know her as Suzette Stradum. When asked why she took back her maiden surname, she confirmed that it was part of embracing a midlife crisis. Suzette will be touching on general legislation, prudential legislation, and market conduct legislation. I'd like to welcome Suzette. Thank you.
Oh, you fall my ding out. Morning, everyone. Thank you, John, for the very long and kind introduction, and it is lovely to be here today. I always say I want to know my audience before I start. I think this thing is I just need to do something here. Okay, don't worry. So I wanted to know from the audience, who of you are brokers? Just put up your hands. I won't ask questions, I promise. Okay. Who of you have been in the industry since before 2002 and before the Phase Act? Okay. And who of you represent underwriting managers? Okay, fantastic. So whenever I present on legislation, I always say that I'm firstly very thankful that I'm up first because you are still fresh. And legislation can be quite overwhelming. And it can actually be such a boring topic. So what I do is when I draft presentations last time, I Googled how to make a boring presentation interesting. And I must say I failed because there's not a lot of guidance on how to make a boring presentation interesting. But I think it's important that we need to acknowledge that because of the fact that we operate in a highly regulated industry, it may be boring, but it's actually extremely necessary. So what I wanted to do today is just to provide very high-level overview of the legislative framework and the legislative reforms. They always say the devil is in the detail, and that is indeed the case. And that's why the rest of the panel, they will go into the detail of the presentation. And for me to cover absolutely everything would take too long. So you always have to decide what is going to be in and what's going to be out. So I spoke to Jean and he provided some guidance. Thank you very much. If I get it wrong, it's his fault. If I get it right, I will gladly take the compliment. So what I'm going to talk to you guys today about is just market conduct, prudential legislation. I also included some recent enforcement action, not to scare you, but just to give you an indication of what the areas are where enforcement action had been taken in the last quarter or so. So without further ado, I think we all know we are bombarded with a lot of legislation. And what I've tried to do in this slide is to just give you a bit of a picture of what the end state will look like once all of this is done. And that is just merely to try and contextualize all these pieces of legislation and drafts and comments that we are receiving on a day-to-day basis. I recently went away for 6 working days, like a week ago, and when I came back to the office on Monday, I went through my inbox as the public officer to just check everything that was released for the past 6 days. And I issued to our exco, I think it was 12, Natasha, 12 pieces of legislation or instruments that were issued in 6 days. And I think what we need to acknowledge is we need to run our businesses from a day to day. We need to make money. We need to grow our industry. And then we have to submit comments on legislation that's coming. And we also need to implement the legislation that has been passed and promulgated. And we need to acknowledge the challenges that comes with that. And if you look at most brokers or insurance companies, and you look at their top 10 risks, I can guarantee you that regulatory reforms or legislation in some type or kind of form will be on the top 10 register of anyone in the financial sector. So, the end state of the regulations, once all of this is done, which will still take a couple of years, is we have the Financial Sector Regulation Act. And that act is like the skeleton. And that provides the framework for a Twin Peaks model of legislation. With the prudential regulation that is informed by the Insurance Act, the market conduct regulation that will be informed by the Conduct of Financial Institutions Act or COFFEE Act, with underpinning subordinate legislation. So we all know in the past there were general codes of conduct, directives, board notices. They called all these instruments all kinds of things, which can be very confusing. So from an architecture point of view, what the regulators did is they said, let's change all of these regulatory instruments into standards. So going forward, you will see a lot of standards that will be issued, either prudential standards or market conduct standards or even joint standards. So there will be a move away from directives and board notices going forward. Then guidance notes will obviously need to continue, as is currently the case, interpretive rulings and regulations. And that is basically the main framework of our landscape going forward. Now, I attended one of the FSB's presentations, and one of the speakers used a very interesting analogy, and they said that the Prudential Authority, or the PA, is like the pa. I'm Afrikaans speaking, so the papa. What does a father do? A father gives money to their children or their wives, hopefully wives as well, and say, there's the money, you go forth and spend it. So prudential regulation or the Prudential Authority, or PAW, is all about financial soundness. And then on the other hand, you have the Market Conduct Regulatory Authority, or the Financial Sector Conduct Authority, and they are like the mother. And they say, please, my son, if you go and visit, remember to greet the people. Be nice now. Open the door. Be kind. Be gentle with everyone. And that is sort of the analogy with the Prudential Authority, or the PAW, dealing with financial soundness, and the Financial Sector Conduct Authority that deals with the protection of customers. And that is ultimately what the end state of the regulatory landscape will look like. So the Financial Sector Regulation Act was passed in August last year, and the effective date was April Fool's Day, the 1st of April. And both regulatory authorities were established, with the Prudential Authority that you can see on your left hand and the Financial Sector Conduct Authority on the right hand. And it's all about a financial system that works in the interest of financial customers. And the ultimate aim of the Financial Sector Regulation Act is to achieve balanced and sustainable economic growth. And that is what we want for our country and what we want for our businesses. And that is the aim that's in the legislation. Okay, so if we look at the Prudential Authority and the Financial Sector Conduct Authority, the FSRA, apparently we're not allowed to say FSCA, so we must say FSCA. Those are the objectives of the two regulatory authorities. And if you look on the screen, you will see all the financial soundness stuff, if I can use that word, is the objectives of the Prudential Authority, and the protection of customers is the main mandate of the Financial Sector Conduct Authority, with the two logos that you can see there. Then, if we look at the ultimate aim and the framework, you will see it's all about a contribution of financial stability. So you get the microprudential supervisors, the respective registers, the Prudential Authority, the market conduct regulators, and then a macroprudential regulator that's responsible for systemic risk, and that's the SARB, and a resolution framework, and it's all about contributing to financial stability. And that is the aim and the short, dumbed-down version of the Financial Sector Regulation Act. So, what are the objectives of the Financial Sector Regulation Act? It is safety and soundness of financial institutions, consumer protection, efficiency and integrity of the financial system, prevention of financial crime, which is very close to our heart as well, financial inclusion, transformation, and confidence in the financial system. And those are, if I look at it from an objective view, those are very clear, defined objectives. Okay, so the Financial Sector Regulation Act also provides for interaction between the Prudential Authority and the Financial Sector Conduct Authority on some key issues. The one is licensing, the consulting on regulatory instruments, financial conglomerates, which won't affect you that much, significant owners, inspections and investigations, and enforcement. But what I want to focus on is specifically this one, inspections and investigations. So we all know the term on-site visits. Those of you that's been the subject of those, not very nice. So on-site visits will fall away. There will no longer be on-site visits in terms of the new framework. It's now going to be called inspections. And then, following an on-site, previously an on-site, now inspection, if it then moves to the next step, which you really don't want to be at, that's an investigation. And please be aware of, if you get notifications and you see the word inspections, it is an on-site visit. It's just a naming convention. Okay. So there's the logo of the Financial Sector Conduct Authority. The FSB is no longer. It has been transformed, as you all know, in the Financial Sector Conduct Authority on the 1st of April. I wanted to ask, have you been on the website of the FSCA? So it's actually quite difficult to navigate. But once you figure it out, I think the most of the stuff is under regulatory framework, where you can find the bulk of the stuff. In many instances, if you can't find it there, and it deals with financial soundness issues, go to the Prudential Authority's website, and you may find it there. So, what are the immediate changes? We know that currently the Financial Sector Conduct Authority has no commissioner. The commissioner has not been appointed. So how do they operate? They operate through an interim leadership structure. On the interim leadership structure would be Caroline De Silva, which you know quite well. Catherine Gibson is on the interim leadership structure. She works from the National Treasury, and we'll see her quite often going forward. Dubit Sidi, the former CEO, he's on that interim leadership together with a couple of others. The position for Commissioner for the Financial Sector Conduct Authority has been advertised. Indications are that the new Commissioner will be appointed by October of this year. Until such time, the leadership would be this interim management committee. Okay. All communication, I'm sure you've seen the communication, is in the name of the FSCA. And we see the logos. And I don't know if you've noticed that the recent communication from the FSCA doesn't include any titles. Did you see that? You get mails from them and you get the name of the person but no titles. And the reason for that is as they're moving into the dedicated market conduct authority, they are relooking their titles and they're restructuring. So we wanted to write a letter to Farzana Badat yesterday. And I phoned and I said, I want to write a letter to Farzana. What's her title? And after 15 calls, I decided just give it up. Just write, Dear Ms. Badat. And it's important that we need to be aware of what's happening in our regulatory authorities because we interact with them. They are our regulator. Okay? There's a new website. There it is. The Financial Sector Tribunal has now officially replaced the appeals board. There is no appeals board anymore. It's now the tribunal. And that's also important for those of you, if you want to appeal anything, be aware of that. And all current board notices and directives are in the process of being reviewed. The reason why is we have new legislation and we don't have registrars anymore, and they need to align these terminology. And they need to consider whether they are going to issue, whether these current board notices will continue to be effective or whether they have to reissue them as standards. So your mailboxes may be flooded in future as well as these directives are being considered and transposed into standards. Okay, the Conduct of Financial Institutions Bill is currently in its final stages. It has been drafted, it has been finalized, and we are expecting the Conduct of Financial Institutions Bill to be released quite soon. You know, quite soon, we never know. But it's quite important that you need to be aware of those developments. What is important is if you look at the Conduct of Financial Institutions Bill, do not expect detail. You're not going to find it in there. The way in which the legislation is drafted, it's drafted as framework legislation. So all the details you will not find in there. And as I go through the presentation, you will see some of the sections that's already been removed out of legislation, and it's now placed into either the insurance regs or into the policyholder protection rules. So look out for the technical details, not in the Act, but in the subordinate instruments. So, pending the development and the finalization of the Conduct of Financial Institutions Bill, the current provisions, the market conduct provisions in the current Short and Long-Term Insurance Act will prevail. So that would be around about, I would say, Section 45 of the Short-Term Insurance Act onwards. Those provisions will still be there. The current Phase Act will still remain effective, but once this bill is finalized, the remaining market conduct provisions in the Short and Long-Term Insurance Act and the Phase Act in its entirety will be repealed. there will no longer be a phase act. And that's also important for us to be aware of. So what did I do? I decided, let me just pull out a couple of important provisions that I think may be of interest to you. And if you know it, fantastic. If you don't, please just be aware of it. As I said, this is just thought leadership for you to be aware of some of the main principles. So the Financial Services Laws, the Financial Services General Laws Amendment Act, was some of the provisions were made effective on the 1st of January 2018. What does that mean? It sounds a bit boring. But what's important is that Section 8.5 of the current Short-Term Insurance Act has been repealed. It's gone. And if you want to look where, you can find it in that very long piece of legislation. So we all know Section 8.5 of the Short-Term Insurance Act. It provides for policy fees. There is a copy of the wording of Section 8.5, and that's been repealed. No more. So does it mean that brokers can no longer charge policy fees? The answer is no. It doesn't mean that. What they've done is they've removed it from the Act, so you won't find it there anymore. Instead, and that's why I said, remember, legislation is framework, the details are in the legislative instruments. So, with respect to the future of policy fees, what they call policy fees, you can find that in the policyholder protection rules. So go and look in the policyholder protection rules with respect to your right to continue to charge policy fees. Also look into in the phase general code of conduct. Essentially, can you charge the fees? Yes. What are the conditions? The fees must be agreed on. It must be an actual service. You must actually say what is the service that you are performing to receive those policy fees. It must not be already remunerated in some other type of form. So it cannot be a commission, an activity for which you receive commission and intermediary service. It cannot be a binder function. And it cannot be an outsourced function. So you need to be able to demonstrate what is the activity that you are performing in order to earn that fee. But you can still earn it. Also, the client or the policyholder has the discretion to stop it at any time. Can the insurer still facilitate the payment of the fee? Yes, but there are certain requirements, and you can find all of that in Policyholder Protection Rule 12, and we have a presentation on the PPRs a little bit later. Okay? And then there are a lot of consequential amendments in that Act with respect to referencing registrars and all the like. It's very technical and extremely boring. Don't worry too much about that. Okay. What else do I think you need to be aware of? The insurance regulations. Now, what I've seen is when one talks about the insurance regulations, we immediately go to binder regs. Remember, insurance regs are more than just the binder regs. It deals with other matters as well. There is a presentation later on the binder part of the insurance regulations. But what is important is, one, it's effective the 1st of January. There are transitional requirements, and you need to check when which requirement will be applicable to yourself and to us as an insurer. You need to know that there's a capping of binder fees for NMI binder holders that are authorized to provide advice, and we'll get into the details later through the other presentations. Also note what's in there. An insurer is required to notify the Financial Sector Conduct Authority if an intermediary receives any remuneration that is not an intermediary service and not a binder fee. So therefore, if you are earning any other types of fees, we are required as the insurer to notify the Financial Sector Conduct Authority. It's a notification, or what we call file and use. You inform the regulator. It's not an approval system. But once they receive that notification, and if we start notifying the Financial Sector Conduct Authority, Don't be upset with the insurers, it's because they have to. It is a requirement in terms of the regulations. And that may trigger them to then ask questions, to say, okay, you are charging a Section 85, a previously a policy fee, what is it for? Are you receiving any leads fee or any other type of fee? And that may trigger those questions. Remember again, it doesn't mean you can't earn them. It is just merely for them to have the oversight of the remuneration activities that are being performed in the insurance industry. Also, the commission caps for short-term insurers are unchanged. They haven't changed it, they haven't touched it. It's still the same. Then, on the insurance regulations, what happened? They've been made effective on the 1st of January, but they consequently published further amendments. Those amendments have been published. They are expected to be implemented on the 1st of July. Will that happen? That's in 2 weeks' time. No. The reason why they won't be made effective is because they need to be in Parliament for a period of 30 days, and they're not going to make it in time. In all indications are that those amendments to the regulations, the new ones, will be made effective around about October of this year. So what is in there? Is there anything in there that we need to take heed of and worry about or consider what the impact will be? Well, I think the second line is something, and the third bullet point is something that we need to consider. Firstly, they strengthen the principles about collection of premiums. Okay? Because what is happening, I'll get to that, Section 45 of the Short-Term Insurance Act has been amended significantly, and Regulation 4 has been repealed. So look at those principles that is in those draft regulations, the new draft ones, on collection of premiums. What must be in the contract, what shouldn't be in the contract. It's quite important for you if you are collecting premiums. Remember that the ultimate aim of collection of premium is that it will be removed as an intermediary service and instead be regulated as an outsourced activity going forward. But the regulators have said that it's premature at this point in time to introduce it, so they are going to continue to regulate the collection of premium as an intermediary service, but only until such time as they've reconsidered it. Then they will remove collection of premium as an intermediary service and instead regulate it as an outsourced activity. When would that happen? I don't know. However, please take note of those requirements. Also, the binder regulations have been further amended to include transformation in the appointment of a binder holder, and that is a provision that's included. I think it's the new QA, whatever provision, somewhere in there. So what we need to know is, as I've said, Section 45 of the Short-Term Insurance Act has been amended, and they've removed the requirement in the draft. It's not law yet. They've removed it to say that a credit-independent intermediary doesn't need to provide security in the form of a guarantee policies. So what does that mean? You've seen the notices. What happened with IGF? IGF issued a notice, and they said they're going to cease operations. Why? Because this legislative requirement for an intermediary to hold the guarantee will be taken away, and it is now the responsibility of an insurer to manage the credit risk associated with brokers that are collecting premium. Previously, it was easy for the insurers. They just said the law says you need to have a guarantee policy. Does it mean that you no longer need to hold a guarantee policy once these regulations are made effective? Yes. However, the insurer needs to mitigate that credit risk. So your insurer may say, but you are collecting the premiums on our behalf, and I want you to continue to take out a guarantee, or it may result in insurers saying you can no longer collect in your own name, you need to collect in our bank account. So there are many ways in which insurers are considering how they are going to mitigate that credit risk. So what happened is the IGF confirmed that it's going to cease operations on the 1st of July. What happened, if I can say a bit of chaos, everybody was very confused. And subsequently, they have said because these regs can no longer be implemented on the 1st of July, they are going to defer that decision that they're going to cease operations. So will they cease operations? They've said yes, but they've deferred it. And it's very important for us to be aware of what's happening there. Okay, are you still awake? Oh, good. Okay. Replacement policyholder protection rules. We all know about the replacement policyholder protection rules. There's a presentation, effective date 1st of January. It was issued under the current Short and Long-Term Insurance Act. Why I'm saying that, you'll hear a little bit about that now. It provides for transitional requirements. For example, the binders, depending on when the binder was entered into, you need to align by a particular date and so forth. It also legislates TCF. Okay, so what's quite important is a lot of people have said, so TCF is not legislation. So why do I have to comply with it? It may be best practice, but do I really have to look at it? Well, the answer is yes, because it's now law. It's in the amble of the policyholder protection rules. There are very important provisions in there. White labeling. If you're white labeling products, please note disclosures before policies entered into on an ongoing basis, renewal of policies, non-payment of premium, advertising, claims, complaints management. And Natasha has the details in her presentation, my colleague from Guardrisk. Okay, so what happened? They published further amendments to the policyholder protection rules, also with an expected implementation date in 2 weeks' time. Now the question is, will those be published in time? I think so. The reason why is they were tabled in Parliament during April, can't remember when. So they are currently before Parliament. And that's why, in all likelihood, these PPRs may be made effective on the 1st of July. And so if you see the PPRs and the insurance regs and you get confused with all these changes, remember there are insurance regs that are currently and PPRs that are currently law, and they've amended it. We're waiting for those dates. And the main reason for that is also to align it with the Insurance Act terminology. There are no registrars, etc. And the PPRs also provide for what they call Tranche 2 amendments. And I don't know if you've seen the RDR update paper was released 2 days ago, I think. And that provides for the Tranche 2 amendments, and it includes micro-insurance product standards. They are currently before Parliament. Okay. Also note phase fit and proper. That's why we have a presentation. Do not underestimate the phase fit and proper requirements. It's a big animal. You need to eat it like an elephant. What do they say? Bit by bit. It's made effective the 1st of April. It was issued under the Phase Act. There are transitional requirements. For the short-term landscape, there are two new phase categories that you need to be aware of. If you have an FSP license, can I ask, have you received a notice from the FSCA to say that your license has been automatically updated with the new phase categories? Okay, so we've received ours as well. I think it was in the last week, this week, yes. So be aware of that. Note that there are other phase categories that will not be automatically included in your phase license. If you want to expand your phase categories, you have to do that by the 30th of June. So that deadline is looming, but there is a presentation on that as well. Okay, and then remember, as a result of all these phase categories, there's a consequential impact on the RE exams. So what I did, the moment that I saw the phase fit and proper requirements, I immediately registered for my KI exam because I didn't write it before, because I don't need to, I actually need to as a compliance officer. But I didn't want to write the regulatory exam on the new basis, because the new regulatory exams are based on the new phase fit and proper questions. So I did, whether it was a good thing or a bad thing, I can't tell you. I passed, by the way. But I think what's important is going forward, the basis of the new regulatory exams will be the new phase fit and proper requirements. Okay? Then there is the specific requirement on conduct of business training and product-specific training, but that will be in the presentation that will follow later. Debarment, so there was a guidance note on the reappointment of debarred reps, and I think this week, last week, can't remember, there was a phase notice 17 with respect to the requirements when an FSP wants to debar its representatives. I'm not going to go into the details, but just be aware of that as well. Okay, then phase draft amendments to the General Code of Conduct, they were published. They are expecting that these new requirements, the new phase General Code of Conduct, will be made effective this year. We don't know when, but the RDR paper, the RDR update paper that was published 2 days ago, I think, 2 days or yesterday, it confirmed that those will be made effective this year. And it's very important that you need to be conscious of those changes. Also, what are we also waiting for? We're waiting for standards. Remember, we are now going to the new framework where there are standards for referrals and lead generation. It will be published for comment. The discussion paper on advisor categorization, which will have a huge impact on all of us. Currently, the thinking is that the regulatory authorities will still continue with the two-tier approach, namely a registered financial advisor that's registered in their own name. And if you don't have any bind or outsourcing arrangement, you can be designated as independent. You are not going to be registered as an independent financial advisor. It is just a categorization that you can add, and you don't have to apply to the registrar for that or the Financial Sector Conduct Authority for that, but there will be some requirements. And then product supply agents, what does that mean? You're an agent of the product supply. Please look out for this paper, and if you belong to industry associations, review it appropriately, talk to who you need to talk to, make the comments. Comments are really being considered in terms of the advisor categorization. And then, it's just because I am in the compliance landscape. I don't know if you know, but the annual phase compliance reports will go away. It's no longer going to be in its current form. It's now going to be called a conduct of business report. So those were published when, John? Last week. See, it's when I was gallivanting somewhere. So they were published last week, and they said the deadline will be moved. It will no longer be when in August, or normally the 24th of August, round about there. It's going to be later. Yeah, comments in July. Okay, so be aware of that as well. Then, if I talk a little bit about prudential legislation and the Prudential Authority. So the Prudential Authority went live April Fool's Day. It happened, gone. It's established within the South African Reserve Bank. If you go and visit the Prudential Authority, it's not nice because it's a key point. You have to add another 40 minutes to just get in the building. One of my friends that work in the Prudential Authority took a selfie in the building, and the security went to him and said, "Give me your phone. It's a key point. You cannot take a selfie in this building." They actually confiscated his phone, and they said, "We'll give it back to you later." And I said, "So I wonder what all the pictures were on there," but they actually confiscated his phone. So there's a lot of security with that building. It's a dedicated website. As I said, if you can't find anything on the FSCA's website, look for it on the Prudential Authority website. So all prudential matters relating to the implementation of the Insurance Act, you can find on there. as opposed to the Financial Sector Conduct Authority's side. Again, it's framework legislation. What does that mean? The devil, the detail, is in the standards. You won't find it in the Act. And the indications are that this Act will continue on the 1st of July. Once this Act is made effective, current insurers, not FSPs, insurers, will not have to re-register or re-license. They need to convert their licenses. And those conversion of licenses process for insurers will be done in tranches. Should you worry about it? Yes. And I'll tell you why. The reason why, I'll tell you now, sorry. So, what are the key features of the Insurance Act? It has a prudential focus. It consolidates the long-term and the short-term prudential regulatory framework in one act. So I'm not that old, I may look that old, but in 1943, there was one act. It was an Insurance Act, which contained both short and long-term provisions. Then, what did they do? They repealed the act, they split it in two. Now, they're moving back, and it's going to be one act again. Okay. Then, it's framework legislation. As I said, the detail you can find in the subordinate legislation. It introduces the framework for insurance group supervision. Why? It's all about too big to fail. And they are going to provide for additional oversight for bigger groups and financial conglomerates. It enhances reinsurance arrangements. And it establishes a microinsurance framework. A lot of people have phoned me recently and said, where's the Microinsurance Act? There is no Microinsurance Act. The microinsurance framework and the licensing of a microinsurer is in the Insurance Act and then in the PPR standards with respect to what will be applicable. Okay. Then there's also other governance-related things, such as who can be on a board, who must be the chairman of your board, etc., for insurers, not for FSPs. So I received a call this week from an FSP to say, there are new requirements for our audit committee. I hear it's in the Insurance Act. I said, yes, but it's not applicable to FSPs. It's applicable to insurers. That's why I didn't expand on the detail. Okay. So there's the objectives of the Act. You can see it on the screen. Fair, safe, stable insurance market, safety and soundness of of insurers, treating customers fairly, access to insurance, transformation, and contributing to the stability of the financial system in general. So why did I say you need to be aware of some of the provisions in the Insurance Act? The current authorization clauses for non-life or short-term insurers has been significantly amended. So these are the new clauses. Okay, motor, not new. Property, agriculture, engineering, marine, aviation, transport, rail, legal expense. Currently, legal expense is written under a miscellaneous clause. Liability, consumer credit is a clause on its own. Trade credit, guarantee, accident and health, travel, miscellaneous, reinsurance. So what's quite important, if you act and you sell these products, you need to just check in with the insurer whether they are registered appropriately. Remember, if an insurer conducts reinsurance business, they need to be authorized for that. Does that mean this will be applicable on the 1st of July? Remember, it's part of the conversion of the license of an insurer. How long does an insurer have to convert licenses? 2 years. But it's important that despite the fact that you are not an insurer, you need to be aware of those changes. So what I've done is I've just added 2 clauses. One of them is motor, can continue to be written personal lines or commercial lines business. There's the definition. Not a shock, should be fine. And then remember there's a different clause for marine. I didn't include the wording because I don't want all of you to sleep. I'm checking if you're all awake still. Okay, then levies. So there's actually a bill that provides for the levies. Will it impact you? Hell yes. It will impact insurers, it will impact FSPs, and the Financial Sector Levies Bill provides for the new levies that will have to be paid. To the Prudential Authority, no, you're not going to pay levies to the Prudential Authority, but an insurer will have to. Levies will be paid to the Financial Sector Conduct Authority, and then there are all other kinds of levies, including levies to the ombud schemes. Be aware of that, look at that bill, and provide for it in your budgets, because the levies will increase. Why? Because the bill in its preamble says, who will pick up the costs of the implementation of a Twin Peaks model of regulation? Well, institutions, we will. And I am aware of the risk that it will be passed on to consumers, but it's important from a budget point of view to take note of how the levies will impact you. And the Act says institutions will pick up the appropriate portion of additional costs to implement the Twin Peaks model, where resourcing is required to enable their supervision. So they are going to the FSCA and Prudential Authority, are currently enhancing their research skills, data and analytic capability, fintech, insurtech, and the like, and the levies will increase. Okay, then the Financial Sector Code. So usually in December, everything happens. So in December, what happened? The Financial Sector Code was made effective on the 1st of December last year. Should you be aware of it? Well, yes, you should. Okay, what is the FSC about? It's about promoting a transformed financial sector through empowerment, financing, and access. Each financial institution will be measured on its own, despite the fact that you may form part of a group, but reporting can be done on a group basis. The targets have been reduced. You can see that on the screen. It's very detailed, and there are priority elements included. Registration of BEE transactions, and there will be oversight by the BEE Commission. So it is applicable to persons that conduct business in the South African financial sector. So it includes banks, long-term insurance, short-term insurance, reinsurance, retirement fund, blah, 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 financial services, intermediation, and brokerage. So it will be applicable on you. It does not apply if you are not trading in South Africa, or if the trading operations is outside the borders of South Africa, and it will not apply to managers of investment for the public who are not regulated by the former FSB, and it will also not include attorneys with trust accounts. So, what is important to note, that there are in the FSC an exemption that's provided for micro-enterprises. So what is a micro-enterprise? If your annual revenue is up to 10 million, then you may be an exempted micro-enterprise, and you need to check what the application will be on you. Also, the Financial Sector Code provides for qualifying small financial institutions. That is, if your annual revenue is more than 10 million but less than 50. Okay? So if you are an exempted micro-enterprise, certain requirements will apply. If you are a qualifying small financial institution, i.e. between 10 and 50 million, then other provisions will apply. So it's very important for all of us to be aware of those as well. For the first time, the FSC now includes priority elements. Those are the priority elements, and why should everyone be worried about it? Because if you do not meet the priority elements, what will happen? Your BE status will be discounted by one level. So make sure that with respect to the FSC, that you address all the priority elements. If you miss one, then you're going to be discounted. Okay, so what is the scorecard? There you can see the scorecard on the screen under other. I included short-term and life insurers as well, just so that you can sort of do a comparison. So those are the points and your scorecard. Oops, let me just go back. So the total for brokerages, intermediaries, will be 105. You will see access to financial services will not be applicable, nor will empowerment financing be applicable. But the rest will be, and there you can see the scores. So the scores will be less than short and long-term insurers, but nonetheless applicable to you. Okay, so let's talk a little bit about some other legislation. We have a presentation on Poppy. Very excited to listen to that. So the National Credit Amendment Bill, specifically if you operate in an F&I environment and if you deal with claims, it's important, despite the fact that you may not offer credit insurance, it's important what is happening in this National Credit Amendment Bill. This bill is also called the Debt Relief Bill, and it provides for a concept of debt intervention by the National Credit Regulator. So it sounds a bit boring, but why should you worry about it? Because it will not only introduce what they call a poor man's sequestration, but it will also expand the National Credit Regulator's function to credit agreements. It introduces new criminal offences, and there is mandatory credit insurance that will be provided for in this bill once it's enacted. But just look at that one. The National Credit Regulator can assist consumers with insurance claims. So if you're going to start receiving calls from the National Credit Regulator and they say, I'm the National Credit Regulator, I want to talk to you about a claim of a policyholder, it's really not an April Fool's joke. You need to be aware that the National Credit Regulator can actually act on behalf of certain consumers that are part of a debt intervention process to talk to yourselves as brokers and insurers with respect to claims. Okay, so the last slide is just to give you a little bit of insight into some of the recent enforcement action that had been taken against brokers or against the insurers, but I think it's important for brokers to be aware of that as well. So if you look at the type of contravention, Section 7(1) of the FAYS Act, it's all about being authorised for the right categories. So there's a lot of focus on that, and that is why if we look at the FAYS Fit and Proper and the new authorisation clauses, please check that your authorizer, check with your compliance officer that your authorisation clauses are indeed correct, because you don't want that. So there you can see the fines. So the 1, 2, 3, 4, 5 fines were all related to not being authorised for the right categories. And then there's one fine that was levied against AVBOP in terms of Rule 5. And what was it about? Relating to authorisation. So if I am a broker, I would just take aware of what the contraventions are about and make sure that your authorization clauses are indeed correct. And then there was one PPR, Rule 16, but it's not the current PPRs, it's the former PPRs. And that was against Smart Life, and it's all about the claims repudiation letter that was not compliant. So the regulators are looking at claims repudiation letters, and although the fine may not be high, there's also a reputational risk associated when those fines occur. And that is my very boring story. So thank you very much for staying awake, for listening to me. Take note of the presentations that will follow from my colleagues and my friends. I call them my friends because they really, truly are. And thank you for the role that you play in enhancing our industry. And you fulfill such an important role. And I always say the best thing to do is to not be on the radar of the regulatory authorities, to avoid inspections and investigations and try and be compliant as far as you possibly can and look at your high-risk areas. So thank you very much for your time. I'm going to hand over to John. Thanks.
Thank you very much, Suzette. Wow, information overload. Suzette, if I can just say, I think it takes, Google or no Google, it takes a really special person with a really special skill set to be able to present those kind of topics with such enthusiasm and being so informative. So thank you very much. Appreciate it. I'd now like to introduce our second speaker, Elsa Jordan. Elsa has been a trusted advisor to many insurers, underwriters and brokers in South Africa on cyber risks, insurance policy wordings and coverage issues. She is well respected in the cyber liability and data protection space and has become a sought-after speaker and author, continually raising awareness around these key emerging trends affecting our industry. Elsa holds a BCom law degree, an LLB cum laude degree from the University of Pretoria, and a certificate in medical law. She has been both a partner at Clyde & Co. and Webber Wentzel, acquiring more than 15 years' experience in insurance litigation and alternative dispute resolution. She joins us most recently from Norton Rose Fulbright, where she was a director specializing in general insurance and dispute resolution, advising on a range of insurance matters, including professional indemnity, computer crime, cyber liability, aviation, medical malpractice, personal injury, and public liability. Elsa will be talking through topics of POPI and then some other legislative considerations. So over to you, Elsa. Thank you.
Thanks, John. Can you hear me? Am I on? I can't hear myself. I'm the odd one out today with my presentation because mine does not relate to anything that's new and that you haven't heard of before, and it's not a new legislative reform. I've made some notes. I was thinking here where I feel like a deer in the headlights. That's the one problem. The other problem is that these days I can't read my own handwriting, so we'll see whether I actually get to read my notes. And Suzette, you're a very hard act to follow, I must say. That was very good. Okay. So what I'm going to talk to you about is data protection and data protection principles and how that has changed globally as well as in South Africa. So there's increased regulation, not just in relation to the financial services industry and the insurance industry, but in relation to industries in general. So data protection doesn't only apply to, obviously, the insurance industry, but to all industries. There are global trends recently. I don't know whether any of you have heard about the GDPR, that is the regulation for the European market and the European Union, where there's increased regulation now on what you can do with personal information and how you can process it. It's a very strenuous type of regulation and it imposes very high fines. The UK have their own data protection legislation, as does the US. Now, as regulation evolves, it also hits our shores. And in Africa, the African countries have woken up and said, look, we need to look at this. We need to look at it from a crime perspective, from a cybercrime perspective, as well as from a data perspective. And there are various countries which are now implementing data protection legislation where that was not really something that was looked at before at all. Now, in South Africa, what we have is legislation as well. I'm going to just list the legislation on the screen. I'm not going to talk through all of the legislation because some of them are in excess of 100 pages, and that would be cruel and unusual punishment for a Friday morning. So while I might quite enjoy looking through all of this, you do not want to hear about all of this morning. So the first, the most important legislation that we have is obviously the Constitution. So what it has and what it sets out is it sets out that you have the right to privacy, but you also have the right to information. And what it tries to do is to balance those rights. So that's the first and most important set of regulations and legislation that we look at in terms of the South African spectrum. Then the Protection of Personal Information Act, that is the regulation of personal information, what you do with it, how you process it, what you can do, what you can't do. Those of you who came to my previous presentation, as I've said to you, the acronyms, all of these acts have acronyms. We can't lag behind the IT industry, which have all these 3-letter acronyms. Some of these are 4-letter acronyms, but in any event, this is, referred to as POPI or in posh circles as POPI, but please don't call it POPI. That is something else altogether. Then you have the Electronic Communications and Transactions Act. ECTA, that came before POPI, but what that basically tried to do is to legislate how we do transactions electronically. So in other words, things like e-filing, verifying electronic signatures. If you wanted to use something electronic in a court case, that is what ECTA does. What ECTA also had in its provisions originally, before we had POPI, and those provisions have now been withdrawn, is to say we think you should implement a set of guidelines on how you should be processing personal information, but as I've said, that's now fallen away because we now have POPI. The Consumer Protection Act, as far as the Consumer Protection Act goes, as well as ECTA, is that it also has provisions on direct marketing. So you would know in your personal lives as well as those of your customers, that people do not like direct marketing. They do not like the calls that they get at what hours of night, and what those acts try to do is they also implement certain safeguards to say, for instance, you can only contact people up until this time. You can put your name on a register to say you don't want to be contacted. If there's direct marketing, you can only contact a person one time. They have to have the option to opt out. Those type of provisions. POPI also, of course, has also sort of adds to that, because I think it is just something that grates everybody's soul. Then you have the Promotion of Access to Information Act. That act just allows you to get hold of information. So in other words, if a public body holds information that you require to assert a right, to protect a right or a legitimate interest, you fill in a form in terms of that act and you can then apply for that information. There are obviously always limitations, but those are the acts that predominantly deal with information and the flow of information in South Africa. Why I've put other legislation is because, as you would know, with the financial services industry, there are provisions which would say, for instance, that we have to keep records for 5 years. You may not destroy records after X amount of time. Same as, for instance, with, let's say, health or medical information. That would be regulated in that bill, and insofar as those provisions are more strenuous than POPI, then you would follow those. But it doesn't make POPI obsolete. You've still got to follow whatever POPI says. I've mentioned the Cyber Crimes and Security Bill, not from the perspective of necessarily dealing with personal information, but it just shows you that the country is aware that there is a need for it. We have a Criminal Procedure Act, but it doesn't deal in detail with what you do with cyber crimes, with people gaining access to your financial information, passwords, and so forth. So that's on the cards as well. All right. So why data protection legislation? As I've said to you, it's to try and balance those rights. It's to try and balance the right of privacy of someone, but also taking into account that you need to have access to information to actually conclude business, to do transactions, to be a country that thrives economically, to actually enable you to transact internationally, and to also align with international standards for the handling of personal information. And as I say, it regulates the flow of information, but in a manner as described in legislation. All right. So yes, it's been a long time coming, but as I always also say to people, is it's not going to go away. It's here to stay. It was signed into law in November 2013, and certain sections came into being in April 2014. Those sections were basically the definition sections. It was basically the sections to enable the information regulator to be set up, and for the minister to make regulations. So the whole act is not in full force and effect. The Information Protection Regulator was set up in September 2016. It's Pansy Nklakula, who was the head of the IEC previously. She's got 4 full-time members, 2 part-time members, and they are in the process of setting up that office. They've said that before they're not operationally ready, the whole act will not come into full force and effect. It was sort of at the end of last year, thought it would be any time between April this year and the end of this year. We'll have to see whether that actually happens. In terms of the Act, you have a grace period in which to comply with the Act. It's a year. But as I've often said to people, a year goes by very quickly. You've got to actually look at implementing what you need to do in terms of POPI much sooner than that. What the Information Regulator's Office has done so far is that the Minister has issued some regulations. The regulations basically they say, for instance, that your information officer within your company has to create certain guidelines and a manual by which you process personal information and so on, and it sets out the forms of what you need to do should you want to make a complaint to the regulator and so on. They have been published for comment. There is an Information Regulator website, and that's what it looks like. That's its logo. All right, so what the Act does is it defines various terms. I'm not going to deal with all the terms, but I'll deal with the more important ones. It identifies 8 conditions for the processing of personal information. As I've said to you, that ECTA tried to do this previously. They tried to say, this is internationally accepted practice, will you please comply with this? But it was not obligatory. In terms of this Act, it is obligatory, and you have to actually comply with those 8 conditions. It is the minimum requirements for lawful processing. If you look at the pages and pages of what it goes into, it doesn't actually seem as minimum as it tries to be. There are quite a few requirements that you have to comply with, but those are now the minimum requirements for processing of information. It delineates a category of special personal information. Now, that information you can only process under certain circumstances. It is usually sensitive information. It's information relating to children, relating to health, relating to medical status. There are carve-outs in terms of that section. For instance, if you are a medical institution, if you are an insurance company, and you need to actually process that to assess your risk. So there are certain carve-outs to those sections, but they just carry higher thresholds of when you can actually process that information and in which way. Then, obviously, the Act now establishes a regulatory body to ensure compliance, which I've spoken about, and details the means of enforcement, sets out civil remedies, offences, and penalties. All right. So if we look at the definition of personal information in terms of the Act, it is nearly anything and everything that you can think of linking back to a person. It's extremely wide. You'll see race, gender, sex, marital status, age, biometric information, that would be your DNA, your blood tests, any unique identifier that can be linked back to you, your educational status, employment history, online identifier, email address. All of those, even private or confidential correspondence or information, and even views and opinions that someone has expressed about you could be seen as personal information. So it is extremely wide. What the Act also does is it defines what a data subject is. A data subject is you, it's your information that's being processed, and that can be a natural person as well as a juristic person. So it's not just individual people, it would be a company registration number, details about the company, for instance. A responsible party is defined in the Act as the person that is then processing the information. Again, it's public, private bodies, individual people. Then in terms of processing, again, you'll see I've put this little paper airplane at the bottom. It's really anything and everything that you think you can do with information is processing. You can just as well fold a piece of paper with personal information and send it, as I say, as a little paper airplane across this room. It really is wide and encompassing. So you have there collection, receipt, recording, modification, dissemination, distributing, anything that you could think of doing. It doesn't need to be automated either. Whether it is written, whether you have an old, archaic filing system, anything that you do with personal information basically gets captured in that definition. All right. So the principles there are 8 principles. The first one is accountability. So in other words, you as the responsible party in processing this information, you're accountable to see that you actually comply with the Act. Processing limitation, that relates to the reason why you're processing the information. So you must only process it for the reason and the purpose that you have actually gathered the information, not for something more. It must be minimalistic and restricted to what you want. So don't ask more than what you want. If we go back to this definition, for instance, is a good example is if you're very concerned about what answer you're going to get when you put the word sex there, is rather refer to gender and have a tick box. Perhaps you just get a little more information than what you bargained for in the first place. Then the purpose specification, same thing. It has to be for the purpose for which you have actually asked the information, and there has to be a justification as to why you have that information. In other words, it has to be for the conclusion of a contract, for instance, so an insurance contract. Then you can process the information. There has to be a legitimate purpose. What the legitimate purpose is, we don't quite know, because it's not defined in terms of the Act. But if there's a legitimate purpose for either the data subject or for the responsible party, you can process that information. You can also process the information if it's required by law, and if you have consent. Now, if we stop with consent for the moment, because you can get away with a lot of these principles if you just have consent. But the consent needs to be very specific. You can't have a blanket consent where you say to somebody, consent to me using your information. It must be, I am gathering your information, I'm going to use it to get an insurance quote or to place insurance. Or I'm going to process your information to comply with all of the terms of the agreement that you've entered into with me. It can't just be you consent to give me the information. And also the consent has to be an actual voluntary expression of will. So it can't be one of those situations where it says, if we don't hear from you, we accept that you've consented. It can't be one of those. It has to be an actual consent given. It doesn't say in terms of the Act that the consent has to be in writing. So you don't necessarily have to have it in writing, but the point is that you as the responsible person, in terms of the Act, you are going to have to prove that you had the consent if that is ever questioned. So whether you have that on tape, on video, however you do it, as long as you can prove that you had the consent, because the onus will be on you to prove that. Further processing limitation. In other words, if you wanted to compare the information or you wanted to send it out to another service provider, that is a further processing of the information. If it isn't in terms of what you originally gathered the information for, then you've got to get explicit consent, and there are limitations on when you can do that. For instance, let's say you wanted to contact your client to sell another product to them which you didn't necessarily previously offer, or so that would be further processing of that information. The information quality, there is a whole section on information quality to say you must make sure that that information is up to date, that it's correct, that it's not incomplete, that you only retain it for a certain amount of what you need it for, that you destroy it when you don't no longer need it, tongue-tied. There must also be openness. What this refers to is the data subject. In other words, you've got to tell them, I'm processing your information if they don't already know. You have got to ask their permission. You've got to say, look, is your information up to date? They can ask you, are you holding information of me that you may be processing that I don't know about? I want you to change, delete, whatever the case is with the information. So there's got to be complete openness about what you do and how you process the information. Then it also requires you to put security safeguards in place to see that what you are actually doing to keep the information safe is reasonable. So there have to be practical measures, technical operational measures that you put in place to safeguard the information. Now, when we look at this, we all think IT security. It's not necessarily just IT security. As I've said to you, if you have paper files that you keep in your office, it is who has access to those paper files? Are they locked in a filing room? Can somebody get easy access to them? Is it easy for somebody to plug into your network and just get access to your systems? And so on. So it's a little bit wider than that. And then, as I've said, data subject participation, they can contact you, they can ask for records, you can ask, you can sort of set a reasonable tariff of if they ask you for 100 records about themselves, of what you would provide and at what cost, but they can be involved and they have to be involved in this process. If there's ever a dispute, if they say to you, you're holding my information, it's not relevant, or you've got the incorrect information about me and you disagree, you've got to actually make that note on your side as well, so that if that's ever questioned or, by any regulator or whatever, that you can show, but I actually made a note, I have it here on my system. All right, so what are the main threats to your business if you think of this? Where would you think your data breaches would come from? Yes, you didn't know there were going to be questions. Anyone? Okay, there are cyber incidents, there are cyber hacks, there are leaks that happen in terms of your system, but most importantly, who works for you? Staff. They make mistakes. They are human, they are fallible, it happens. So I thought I'd put in this short little video clip, which I hope is going to play, just to illustrate to you how humans react to certain things. It is an American video. It's prior to the new political dispensation, but I thought you'd quite like this in relation to passwords.
We've been hearing a lot about cybersecurity lately, largely because of what happened to Sony. Companies and individuals are more concerned about the safety and privacy of their information than ever. President Obama has unveiled a number of new proposals this week to crack down on hackers, and he plans to address this in the State of the Union speech on Tuesday. And it's great that the government is working on this, but the truth of the matter is we need to do a better job of protecting ourselves. You know, the most popular password in the United States is password 123. And as long as that's the case, we're vulnerable. So today we sent a camera out on Hollywood Boulevard to help people by asking them to tell us their password. And this is how that went.
We're talking about cybersecurity today and how safe people's passwords are. What is one of your online passwords currently?
It is my dog's name and the year I graduated from high school.
Oh, what kind of dog do you have?
I have a Chihuahua Papillon,
And what's its name?
Jameson.
Jameson. And where'd you go to school?
I went to school back in Greensburg, Pennsylvania.
What school?
Hempfield Area Senior High School.
Oh, when did you graduate?
In 2009.
Oh, great.
It's like my cat's name and then just like a random number.
Okay. Have you had this cat for a while?
Yeah, she's my childhood pet.
Aw. And what's her name?
Her name is Jolie.
Jolie. So like a password of yours would be Jolie and then a number.
Yeah.
Like number 1?
Like my birthday,
Oh, when is your birthday?
June 12th,
Oh, nice. And what year were you born?
95.
Oh, great. So Jolie, 6, 12,
Nine.
95.
Yes.
Got it.
So you mean to give my password right now? No, I cannot do that.
But we all want to know what it is so we can tell you if it's strong or not.
Oh my goodness. Let me think. Okay, one is Tel Aviv. Yeah. 468, and then Israel. It's only 3, but it's for me it's strong enough.
Ireland, 1, 2, 3, 4.
Gemma, 1, 2, 3. Spelled Gemma.
Well, most of them are Italian.
Oh, beautiful.
Yeah. So
like what's a good Italian password?
my grandma's name,
What's your grandma's name?
Maria.
Maria. So Maria is your password?
Oh yeah, now you know my password. Oh yeah.
Yeah. Well, the important thing is they learned a terrible lesson.
Okay, so that just shows you how easily people give away information without even realizing, without even necessarily knowing. So what do you need to do to safeguard from your side, to put in reasonable measures to see that things are being safeguarded? It's never going to be a foolproof method that you can actually employ, but what the Act basically says is reasonable measures, operational and practical. You've got to audit your data to see whether you should still be having it, whether it is up to date. You have to have knowledge of the legal requirements and also recognize the risks and security breaches that may be prevalent in your company. And then you've got to establish the data protection and breach principles and procedures and policies and training and guidelines as well. As I've said to you that in terms of the regulations, the Minister has now said, companies, please start preparing a manual on what you do with information, how you would process it, what you would do when somebody asks you for information so that you have those policies and procedures in place. Another thing that I just wanted to say now that we're talking about employees is that when we think about personal information, we often think our clients. We think our clients, our customers, their information. But as I've said to you before, because it is so wide-ranging, it's also the information of your suppliers. It's also the information of your staff, your personal information. So just bear that in mind as well. All right. So the process. In terms of the Act, the process can start with a complaint to the regulator. What the regulator can also do is initiate the process themselves. The regulator can look at an industry or at a business and decide that I'm not happy with what's happening here, or I need to explore this further, and she can actually start the process herself. It doesn't need to necessarily come from a complaint. And then the regulator will investigate and will decide. The thing is about the Act, what is very important to know is that when you do have a data breach, it is now compulsory for you to tell the data subjects that are affected that I think your information has been compromised, I think it has been used in whatever manner, and you also have to notify the regulator as soon as reasonably possible. We at least still have that provision in our Act where many other companies have a time or a day period. Like for instance, instance, the European regulations, which I spoke about earlier, has 72 hours. Then you've got to let them know. If you don't let them know, it's an offence in terms of the Act. Same in terms of our Act, but at least the reasonable time period gives you a little bit of leeway. You've then also got to tell the regulator, what was compromised, what you think the outcome may be, how many data subjects have been affected, and what measures you've put in place to deal with that. Now, the regulator has an arsenal of methods available to her. There are all these notices that she can issue. For instance, an information notice to say, I want this information, I want to come and investigate what you are doing. An enforcement notice to basically say, stop what you're doing, I don't like what you're doing, you have to comply with this. Or an infringement notice that usually goes together with an administrative fine to also say to you, no, stop, what you're doing isn't right, I don't like that. There are provisions for appeal and so on certain of these notices that one can take in terms of the Act. There's also search and seizure provision in the Act, so they can also come to your company. It's there are reasonable timeframes and measures. They have to let you know and so forth, but they can also actually arrive at your company and look at information, seize information. They can also issue warrants. If they think you are hiding something, they can apply to court for a warrant, come and seize information or stop you from doing something. What the regulator can also do is issue codes of conduct. Now, that can be about the processing of certain types of information. It could also be in relation to an industry norm, to say that the insurance industry can process information in XYZ fashion, and this is the way you can do it. Up to date, there aren't yet codes of conduct. We're still in the early stages. All right, so there's a section in the Act as well that tells you what are contraventions and what they look at in a serious light. There are also sections that deal specifically with financial information. So they'll say that, financial information of a person or account information goes missing or is used in an unauthorized manner. It's a contravention, and especially if you could see if it's of a serious or persistent nature, likely to cause substantial damage or distress. If you knew and you could have taken reasonable steps and you failed to take reasonable steps to prevent that. Okay, sanctions. So the responsible party can be convicted of an offence or be liable to pay a fine or to be imprisoned depending on the nature of the offence. Now, usually this would be the MD or the CEO, Doug, of the company. So what I usually say to people in terms of, I don't know whether any of you have seen that little tree with the birds sitting and how the crap travels. So what I usually used to say to my clients is delegate down as much as you can. The Act imposes strict liability. So in other words, you don't necessarily have to be doing something wrong. If there was a security breach, you are responsible. In other words, if one of your employees by accident dropped a memory stick in the parking area, if that comes out, if there is that breach, it is liability in terms of the Act. So as I've said, there's also, because of that strict liability, there may not have been any conduct on your part to have led to that breach, and therefore there are administrative fines that you can pay. You can also contest, or you can decide you want to rather contest them in court. And as I said, the responsible party may be prosecuted. Now, there are certain defences, such as if somebody, a data subject makes a claim against you, puts in a complaint, brings a civil action. It may be that, some of the defences are that you had the consent of that party to do with the information that you did, and there may be fault on the part of the claimant. In other words, if they make everything public, as we know that some generations these days do, on their Facebook, it would say their name, their age, what they do for a living, where they stay, I'm traveling from here to here. If it's in the public domain, if they've made it public, that is a defense. And there are a few other defenses as well, just to take note of. And then what's also important to just know is that the breach of the data protection conditions, and if there is a civil claim that comes out of it, as I've said to you, the regulator can also assist a person to make a civil claim. So if it's an indigent person that does not necessarily have the means to bring a civil action, they can also help to do that. And what you can now get is damages, that's your patrimonial and non-patrimonial damages, for a breach of privacy that was relatively little damages that you could get. It was not a major case, and people usually didn't take it much further. But now what the Act says is that you can get aggravated damages. Now, aggravated damages isn't a known or a defined type of damage in our law. I don't think, and I don't know, but I don't think that this will be applied as in the American system, where it is very much a sort of a punitive rap you over the knuckles type of damage that is completely out of kilter with the offence that you have committed. I think it will be judged in a way to say that, how did the responsible party act? In other words, if they knew there was a breach, they didn't tell the information regulator, they took no steps at all. I think what the courts will do is to say, in this case, we're awarding you that little bit extra because of your conduct. If you acted reasonably, I can't see why that should be imposed, but in any event, there it is, it's new, and we'll have to see what happens. And then obviously you can have legal cost, interest, and publication. Now, for a lawyer, the publication is a little bit of an issue for me, because if you notify the regulator of a breach, if they think it's a substantial breach, they can publish it. Can publish it on their website, they can publish it in the media. If there is a court case that is made, and even if there's a settlement, or it's withdrawn, or the parties come to some sort of compromise, what the information regulator says is it still needs to be published. And they will still apply to court to have that made an order of court. Now, from a legal perspective, that is something that lawyers don't like at all, because you settle cases without prejudice specifically for that basis. And you don't necessarily want everybody to know. So now there is the shaming and naming provision in terms of the Act that you just need to be aware of. Okay, so some international examples. Our Act follows very much the previous European regulation and the wording. So one would have thought that in terms of fines, penalties, what may happen to you, our regulator will again just look at what is happening internationally. So these are some of the naming and shaming provisions on the UK website, their Information Officers, Commission Officers website. Prodal, a company that had these automated nuisance calls, that was one of the very high fines of £350,000. An employee of a car rental company was prosecuted for obtaining and disclosing and selling information. A monetary penalty for a town council where an unencrypted laptop was lost, was left on a train, an employee's laptop, and there it went. Monetary penalty for £100,000, and that was when sensitive information was sent to the wrong recipient. This was in relation to a child, indecent assault type of case, so the Commission saw that in a very serious light. There have also been, when you fail to notify, there are fines. All those details are on the website. Also, if a company has to comply with information notice or an infringement notice, that also gets published on the website. Now, that's a rather big fine. TalkTalk was fined also £400,000 for security failings due to a cyber attack. The next one in America is even more alarming, $25,000 for a data breach. From the regulator, and then there was Zurich was fined, and this was quite a while ago, you can see there 2010, for 2.27 million, which was going to be 3.25, I think, million, but they entered into negotiations with the Financial Services Authority to get that down. What happened there, incidentally, is that they stored information in South Africa, and the information went missing, and they didn't realize until a year later. Now, the alarming thing about that is up to date, there's been no proof that these records have been used or accessed in any way. But that is the harsh penalty that you get for losing information and not being aware of where your data is kept, how it's kept, and where the security safeguards are in place. Bringing it back to South Africa. Who heard, by show of hands, about this big, large data breach at the end of last year of real estate? One person, two people. So very few. So it actually hit our shores as well. Over 30 million records were just made available on the internet due to security failing. High-profile individuals, Jacob Zuma, Fikile Mbalula, quite a few other high-profile individuals, all the information was just available on the internet. The company had no idea. These Jigsaw Holdings, as well as the real estate companies attached to them, they had no idea that this had actually happened. It is most probably one of the biggest data breaches in South Africa to date that we know of. If the information regulator was fully up and running, I can just imagine what would happen there and what type of fines and penalties would come down on them. Then also, very recently, telesales call made to King's Goodwill's Willatini, and it was leaked. And it was a conversation between a MyWay salesman, and the information regulator got wind of that and actually issued a statement. MyWay, apologized profusely, but they basically said it was unauthorized processing of information. There was no reason why they needed the information, why they had the information, why they made the call, and it was completely unlawful, and the information regulator is actually engaging with MyWay to see whether they have procedures and policies in place to deal with information. And that they have the right tools in place. So, the last thing you want is for the information regulator to come and knock on your door. So they were actually just quite lucky that the whole regulator isn't properly up and running yet, and that they don't necessarily are going to face a fine. So that was that. I believe questions are afterwards, so we can deal with them then. Thanks.
Thank you, Elsa. I'm quite relieved to hear that the Poppy Act hasn't got something to do with nice pretty flowers in my back garden. I see some people nodding here, so it's not just me. Guys, we're going to break for 15 minutes. We've got to be back at 11:30. So please enjoy some refreshments in the foyer, and we'll see you back at 11:30. Thank you. To the second part of the session this morning, I'd like to welcome up our third speaker of the day, Natasha Holt. Natasha Holt has 8 years of insurance experience, which includes complaints management, quality management, and call center management. Natasha joined Guardrisk after being with an insurer for 5 years and has brought her knowledge and skill with her. Natasha is focused on customer centricity and has customer service management experience. In the last 3 years of her employee with Guardrisk, she has headed up the complaints management, which has evolved due to changes in the legislation, into what is currently the Market Conduct Department. Natasha and her team are responsible for all market conduct related issues, TCF, CBR, complaints framework, as well as the Guardrisk data project. She's focused on the principles on TCF and has vast exposure to the implementation of these principles. Natasha is also well versed in managing customer experience, highlighting areas for improvement to better manage risk. A key skill set is her ability to translate process into system integration. And Natasha will be touching on Poppy and the CPA. Over to you, Natasha. Thank you.
Thank you. All right, so morning, everyone. Thank you for your time this morning, and thank you to CIB for the invitation to speak to all of you today. So basically, as part of the presentation for market conduct, I'll be covering the policyholder protection rules, which also speak to TCF, and then something big changing in the industry, which is becoming a data requirement. And, big data is a big topic in the industry at the moment, and the requirements for data specifically throughout the value chain, so from the broker to a CIB to a Guardrisk environment, is really becoming more legislated, as we'll see within the next year. And I'd just like to have some high-level discussions around data as well. So in terms of the policyholder protection rules, Suzette did cover some key items a little bit earlier, but extensive amendments which give effect to market conduct initiatives, effective with specific transitional timelines for specific rules from 1 Jan this year, and now to note that they don't apply to reinsurance policies, as well as it now is becoming a requirement that everyone in the value chain must be able to demonstrate and not just provide lip service that we treat our customers fairly. It's now becoming an evidence-based exercise. And of course, things to note, specific changes are now the definition of a policyholder. So before it used to be somebody who is actively has a policy, is paying a premium. It's now moving into the frames where somebody is interested in a policy or somebody sees an advertisement. It's taking it very far in terms of what is a policyholder or potential policyholder, as well as group schemes. There are now going to be some extensive requirements for group scheme-related business under the PPRs as well. So I'm going to take you through a couple of the rules, very high level, because I trust everyone has read every piece of the policyholder protection rules, but more specific rules that I think have an effect on you and your environment and the way that you operate within your business. So obviously we'd like to keep it relevant. I don't want to bore you with unnecessary topics that don't apply to you. Pardon me. So from the 1st of January, product development, you'll notice that on the top of every slide I've indicated the actual date that it's coming to effect. So we're speaking first to product design and due diligence. So when developing a product or making changes to an existing product, the insurer, which is Guardrisk in this instance, must identify the needs of the types, kinds, or categories of policyholders. So again, you'll notice that the PPRs speak a lot to TCF and have now formally legislated TCF. So, if you wanted to know how do I apply TCF in your business, if you just implement what the PPRs are asking you to do, essentially you'll be treating your customers fairly. I don't doubt that anyone here has not been treating their customers fairly, otherwise you would not be in business. So please don't approach it from a point of, I need to start doing everything over again. Just change some things about the way that you're doing business currently, and you should be covered. All right. So we also need to undergo thorough assessments of the product, distribution method, as well as disclosure documents. And there is a requirement that Guardrisk must confirm compliance with all of these rules before inception on a new product. So before, if somebody wants to launch a product, you go to market and we fix the problems afterwards. Unfortunately, the regulatory environment is changing. The new way of doing business is we must understand our customer, know the product is relevant to the customer, and understand that it's something that is going to benefit the customer at the end of the day. I mean, you are all consumers. I'm sure you've made some bad choices in some of the products you've bought before. And if somebody had taken a bit of time to take a step back and analyze, research, make sure that there was a need, some people wouldn't be feeling as hard done by as customers or consumers sometimes are. You find yourself in a position, I should have never taken this cover. Just feeling sorry for yourself. White labeling, Suzette also touched on it earlier. Due diligence must also be done respect of governance, resources, and operational capability of outsourced partners. So there are going to be additional requirements in terms of, how long the arm of the insurer extends down the value chain moving forward. Rule 4 speaks to cooling off rights. I've specifically just kept short-term related issues here on the cooling off rights slide. So where it speaks to policy term for longer than 31 days, where no benefit has been paid or claimed, the insured or member of the group scheme may give an insurer a notice of cancellation, and then short-term specifically, 14 days after the date of receipt of the policy contract, from a date on which it can be deemed that the policyholder received the contract. So again, it's not just about saying I've issued you with wording. You need to be able to prove that someone received that wording. Okay, so, it's not just about sending it out into the universe and the email bounces back and you do nothing about it. Those are the practical implications. Is there somebody that checks, was the email delivered? Because then we can confirm you've received. Because we know we all have had a capture error at some point in time. Capture one letter correctly, one detail left out, and an email bounces back quite quickly. So, it's about those small checks and balances that you need to put in place to make sure that you're able to meet the requirements under PPR, or treating your customer fairly to make sure that they get that policy information. You will then also have an onus to follow up and put a process in place to make sure that you are communicating directly with the customer. All right? Premiums or monies paid up to the date of receipt of notice must be refunded, and the insurer can deduct a pro rata for risk cover actually enjoyed. So in other words, if something had happened, we would have been on risk. All right. Determining premiums and excesses. So premiums and excesses must balance the interests of the insurer as well as expectations of the policyholder or members of a group scheme. So this is effective from 1st of July. We may not charge any fee in addition to the premium payable unless it's provided for explicitly in the policy or permitted in the terms of legislation. So as Suzette referred to earlier, there are a number of fees that are now going to become regulated. Make sure that you adhere to the regulation and the maximum limits in terms of those fees, for example. And then any fee referred to above must be clearly disclosed to the policyholder before the policy is entered into. So there should be no hidden T's and C's or, as part of the overall policy premium, if there's a different amount for something that does not constitute policy premium, it must be disclosed explicitly to the customer. Advertising. So any advertisement placed, social media, because I see a lot of people are also advertising their businesses on Facebook. Whether you're handing out flyers, whether it's on a TV, whether it's a radio ad. There are specific requirements to make sure that the customer or the end user customer is aware of who the underlying insurer is. So you'll see that we have put an approval process in place where we now need to review all types of advertising material that is made available to the public. We've communicated a process. If you would like to understand more about that process, please feel free to chat to us or to chat to CIB, who's been made aware of the process as well. All right, and then descriptions of policy or service must not just include benefits, but also in terms of fair and balanced information being provided to a potential policyholder up front. It includes things such as limitations, exclusions, risks and charges, and must be factually correct, balanced and not misleading. So the act can't just be about, if you're going to lie in hospital for 10 days, we'll pay you 100,000 Rand, call us now. If you've seen any of those type of ads, but it needs to be factually correct. You need to make sure that the consumer can listen to the ad and understand that, it's not just about getting 100,000 Rand after 10 days. There are terms and conditions that go along with that. And then disclosures. So this is a big one. Officially applying to all communication from the 1st of January next year. So you've got about 6 months to prepare yourself and change your processes. And this is a big one, especially in your world. I now spoke to Antoinette earlier outside. As a broker, you feel, what more can we say? What more can we do? And the reality is, you're required to do a pre-quote, you do a comparison, you fill out lots of documents, you reassure. There's a lot of work that goes into securing that policy at the end of the day, and we understand and appreciate that. So just review your current process against what the disclosure requirements are, because there are certain requirements for disclosures before, after, ongoing. So again, do you sell a policy and don't hear from a customer again until something goes wrong? So they debited incorrectly, or they claim, or they cancel? Or have you kept in contact over the last year? Renewal disclosures, so specific requirements for when somebody renews, what needs to be done and what needs to be disclosed, as well as disclosure when a premium is missed. And that's a big one. We all rely on policy wording to say, well, the policy wording said that due unmet premiums, policy lapses, but there are now going to be more rigorous requirements in terms of some action from your side to make sure that the customer is aware of the implications of not paying their last premium, for example. Then arrangements with intermediaries. Some of this was covered earlier, but from 1 July next year, all intermediary agreements must be entered into directly between the insurer and the intermediary. We've already started a process from Guardrisk's side where we will then be rolling out contracts to intermediaries, which will then allow us to cover this requirement under PPR sooner rather than later. And again, the insurer may not facilitate deductions of any other fees unless satisfied that the amount and purpose were explicitly agreed to by the policyholder in writing. Okay, so that's exactly what PPR says in terms of those fees. And then it needs to relate to an actual service provided. It needs to be related to a service other than rendering services as an intermediary, and is not remuneration or payment for something that's already paid by the insurer. Okay, so Joanne has sent us a specific query relating to this. We are formulating a house view, and we will be in a position very shortly to provide a response and guidance in terms of, these specific fees, because I know it's a bit of a sore point for some. All right. Then data management. So PPR requires that there is more data held by the insurer. So there's an age-old fight about who does the customer belong to. The broker says it's mine, the insurer says it's mine. The reality of the situation is that if something does go horribly wrong, we must be able to pick up that book of business and continue a seamless process with that customer so that they are not negatively affected in the long term. So for example, some examples that have been cited in the past, Saxum, for example, went under, policyholders didn't know who the insurers were, they didn't know who to claim with, policies were not debited, so at the end of the day, the customers were very negatively impacted by the fact that the insurer did not have data or have access to data. So PPRs is now saying that there is specific policyholder data that we require, and I mean this goes down to name, surname, ID number, contact number, email address. And if you're already passing information on in terms of what you capture that doesn't cover these minimum requirements or these basic requirements, you then need to start looking at how we're going to up our game to make sure that we start getting this information, that information is accurate, that remains relevant, and that it continues to be updated on a regular basis. So from our side, we've initiated a massive data project. Naturally, we deal with CIB in terms of the data project currently, where they supply Guardrisk with data, but at the same time, they rely on you to supply them with data. So, it's moving on to a 30-day cycle. The target is for 1 Jan 2020, as per PPRs, to be on a 24-hour data exchange cycle. So to sit there with a proposal or an acceptance of a quote for 30 days and do nothing with it, or only update your records every 30 days, is not going to be acceptable in the near future. It's going to need to be on a 24-hourly basis, that you make sure that new information is captured, that it is provided. All right. And then the registrar can change data requirements at any time. So I'm not going to stand here and tell you that these are the final last. I mean, there are some amendments being made to the PPRs, various tranches. I think, if anything, Suzette's presentation tells you that there are so many moving parts that, have a knock-on effect on each other, that please don't, understand that at this point in time that this is all we'll ever have to provide. It may change in the future. Then record keeping. So again, 1 Jan 2019, insurer or SAL must have systems, processes, and procedures to record all policy-related communications. So similar to Elsa's presentation in terms of POPI, PPR also speaks to timelines. You should be able to store and retrieve documentation, keep them safe from destruction, may be kept in electronic or recorded format, must always be easily accessible. So for example, if a client complains, we are then going to come and say, okay, we'd like, the application form, we'd like, any other information relating to the policy that was then activated. We can't wait a week or 2 weeks, to retrieve that information. That's what easily accessible means. If it's a voice recording, it should be readily available. It shouldn't be a matter of, oh no, we need to go to Metrofile, and that's going to take 30 days for us to get that information. That no longer is going to be acceptable in terms of PPR. And records must be kept for at least 5 years and must be made available timeously to the registrar, policyholder, former policyholder, or beneficiary on request. And then Rule 17 claims, and also Rule 18, which speaks to complaints management. If you are processing any types of claims, because I saw a couple of people that were part of UMAs or brokers, if you do have specific functions that you're performing that relate to claims administration, I would strongly recommend that you go and familiarize yourself with the requirements under claims management, because it is very different to the way we're currently doing business. So there is a 12-month transitional period. So again, 12 months in your space speaks to December this year, which means it's going to become a requirement very soon. The definition of repudiate is something you need to also familiarize yourself with. Repudiation, according to the way we understand it currently, is not necessarily what the PPRs call it in the future. And then claims management framework. So the PPR speaks to, you need to have a claims management framework in place. It needs to be accessible to your policyholder. It needs to be easy to understand. So, I don't need to know how to process or how I'm going to lodge a claim only at the time of claiming. Your customer needs to know up front. And have they been given that information, and is it accessible? Representations. So obviously if someone's unhappy about their claim, we must allow them to come back and make representations in relation to same. Again, there are very specific data requirements for what needs to be kept and processed in terms of claims. So that's also an additional data requirement, for example, that relates specific to claims. Communication. So communication under claims speaks to how often you should communicate. What is acceptable, what is not acceptable in terms of timelines when handling a claim. And then analysis of claims data. So, we process all these claims on a monthly, weekly, yearly basis, but does anyone actually look at those claims? And does anyone actually identify, listen guys, we have a training gap, for example, that, when we're selling this product, we don't necessarily highlight this clause. And that clause keeps coming back as a claim, and clients are not happy when their claims get repudiated. So perhaps we must highlight this up front or make customers more aware. So it also speaks to, when you do any type of analysis, use that to educate your customers. Because your understanding of a product may not be your customer's understanding of a product. And I know we all sit there, and I say we all do, because we're all consumers of somebody else's products as well. And you just want to get out there, sign, yes, 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 I understand. Listen with half an ear. It's, you know, human nature, I do it. And I mean, I'm trained to make sure that I understand stuff. But again, if there are specific things, and because we know we listen with half an ear, or we just want to sign and get out of there, highlight, educate your customer, send, you know, email blasts or SMSs, you know, when you do updates or whatever the case may be on recent trends picked up, things that may be beneficial to them and their understanding in terms of having this insurance product, for example. And then complaints management also, 12 months transitional period. Definition of complainant is stretched. Again, anyone can complain, anyone can be a complainant. You don't necessarily need to have a product to complain. And then a definition of complaint. So in the broker environment, I know that we've always applied the concept of, you know, phase-related complaints management policy. And the complaints definition speaks to something wider than phase at this point in time under PPRs. So please be aware of that and apply it correctly. Again, things like, I will only accept a complaint in writing is no longer going to be acceptable. You should be able to receive it on email, on telephone. So again, please be aware, because this is going to have a major impact on how you deal with complaints moving forward. There's different terminology also, as in the case of claims. Certain things, for example, ex gratia payment and compensation payment, there are specific definitions related to same. And again, you need to have a complaints management framework in place. So I don't only need to know how I complain when I'm calling you to complain, but I should know about it as a standard. And then also data requirements under complaints, as well as how to analyze, or what sort of analysis are you doing with your complaints data, and is that information being fed back into the product cycle? Because unfortunately, 9 out of 10 times, you know, the complaints person always feels like, oh, it's the salesperson who's the problem. Or the complaints person feels like it's the claims person who's the problem. You know, because we all blame someone else. Yes, I see some people, yes, I agree. It's always the claims people. You know, they just pay these claims and just sell properly. You know, we're all just pointing a finger at someone else in the room. So analyze the data, feed that information back into the value chain. Because if you as a broker sitting there every day and you're like, this claims process doesn't work, then say something. You know, just educate the process going up as well. And if we find that a product's not being sold correctly, or there's specific issues with policy terms and conditions, then changes need to be made. It's the reality of the situation. It's senseless for us all to be sitting on the problem and hoping it goes away, because it never does. And unfortunately, 9 times out of 10, it ends up at the FSCA and becomes, you know, blown out of proportion, which we've seen in some cases with you know, unnecessary complaints that could have been resolved at source. And then termination of policies, Rule 19, there's a 24-month transitional period. Again, there's a specific definition when it comes to what constitutes a termination of a policy. Notice periods are covered for terminations. There are specific rules related to individual terminations, group scheme terminations, replacement of policies, as well as how you need to communicate through a termination process, and terms and conditions. All right, so please, these last 17, 18, 19, as well as disclosures, are quite rigorous in terms of what the requirements are. So please familiarize yourself with those. Yeah, and that's it, short and sweet. Thank you for your time.
So much information. Wow. I think I was lost at Suzette's slide 2 this morning. So, now on a serious note, I think if I can just spend a minute just to say that obviously Jean, our compliance officer, in conjunction with Guardrisk, are working tirelessly just to ensure that our operating model obviously fits into what the requirements are. And yeah, the guys are doing a hell of a lot of work behind the scenes just to make sure that we are compliant, and obviously assisting brokers to get there as well. So so watch the space. We realize that there's a lot to take in, but we will do our bit to help all our partners. I'd now like to call on our last speaker, Christine Rodriguez. Christine is a partner at Hogan Lovells in the Financial Practice Group and heads the insurance practice in South Africa. A leading financial services lawyer in South Africa, she focuses on regulatory and commercial and corporate transactions affecting the insurance industry. Christine advises insurance companies, brokers, as well as the insurance industry bodies on regulatory, governance, corporate, and commercial transactions. Today, Christine will be touching on the impact of fit and proper and the binder regulations on the intermediary, new fit and proper requirements, and the cap binder fees, the definition of associate, and data integration. So over to you, Christine. Welcome.
Good morning, everyone. It's the home stretch. Prior to just starting my presentation, I just want to touch on something that Natasha spoke about in terms of compliance and the need for it, and the value that it creates in your business. I'm personally involved in the Saxum liquidation. I've been advising the liquidators on the insurance aspects in terms of non-compliance. And I just want to say that you should feel very thankful that you are dealing with a sophisticated underwriting manager as well as an insurer that actually has those operational systems in place and policies in place, because what's transpired with this liquidation is how you take an organization that does not comply with every single aspect that's been discussed here and how detrimental it is to insurers in general, to underwriting managers, to brokers, and ultimately the policyholder. And what you don't realize is that having those policies and processes in place actually adds substantial value to your business, because it creates a trustworthy relationship with your client that they know when engaging with you and in turn in engaging with the underwriting manager and with the insurer, that there's stability in them parting ways with their premium. So just keep that in mind. And also, these regulatory changes are not particular to South Africa. I mean, this is a global change that is happening in quite a lot of sophisticated regulatory regularized markets. And in fact, in certain instances, South Africa is way ahead of other sophisticated markets. So we are moving towards that regulatory regime. And there's no point in complaining about it, and just get on with business. All right, so I thought before we get into the nitty-gritty, we could kind of play a game in terms of, as you know, we are all service providers. So you're not feeling well, you go to the doctor, and the receptionist says that you can choose between two doctors. So behind door number 1, you have Dr. X. And Dr. X has been practicing for a while. Every year he takes a refresher course on general medicine. He reads 2 medical journals every month, which obviously he's quite bored. In between he's consulting with patients. Every year he attends an international conference where he updates himself on new alternative medicine, and he keeps up to date with the industry that he's in. Then we have behind door number 2, we have Dr. Y, and he's been in practice for only a year, and he doesn't believe in taking refresher courses like Dr. X, and when in doubt, and when the patient's not looking, he Googles just to make sure that his prognosis is correct. And he doesn't believe in keeping up with new techniques, alternative techniques, and alternative medicine. So the question I ask you, which doctor would you choose? The doctor behind door 1 or the doctor behind door 2? So you would never allow yourself to be subjected to somebody that doesn't have the necessary skill, expertise, and experience. So why would we expect our clients to expect anything other than that as well? And that's exactly what the fit and proper regulations are attempting to do. So they came into effect on the 1st of April 2018. And what's interesting, you see that they've expanded on to the previous requirements. And we'll briefly touch on all the requirements. So the personal character qualities of honesty, integrity, and good standing, you'll see applies to the actual financial service provider, the FSP, the key individual, as well as the reps, okay? Now, I'm not going to go through all the list of qualifying criteria. It's quite, you'd have to look at the regs. But for example, you won't be considered to have honesty, integrity, and good standing if you've been found to have breached a fiduciary duty, if you've committed an offence under POCA, if you've been convicted, etc. And that list has been expanded from what was previously stipulated. Now, with key individuals and representatives, that's quite easy to determine. But in terms of the FSP, that's a juristic person. The way that this criteria would be determined would be by the actions and the behavior and the conduct of the financial service provider in the industry. All right. Oh, sorry. Let me go. In terms of competence, this becomes the responsibility of the financial service provider. So as an FSP, you have the responsibility to ensure that the FSP, the key individuals, and the representatives under your FSP license remain competent in terms of the Phase Act, okay? And again, there are minimum requirements that have been set. And the minimum requirements are appropriate experience in respect of the financial products that you're offering in the particular category of the FSP, all right? In terms of key individuals, it's not only about knowing about the product, it's also about having now appropriate experience to manage and oversee. So you will see that this will make, as Suzette touched on, those regulatory examinations will become a lot more onerous for key individuals because you will have to know how to manage and oversee your reps in terms of the products that they're offering. If your experience lapses, if you are not offering any services for a period of 5 consecutive years. So what the FSCA is attempting to do is to prevent people, and this is likewise in terms of the conversion applications with insurers. So what they're preventing is you go out, you do regulatory examinations, you become qualified in everything, just in case you one day want to offer a particular product. They're forcing you to become experts in a particular field, and if you then want to expand outside, you then have to obtain the necessary expertise in terms of offering those products. So they're forcing you into really hone in and becoming a master of whatever financial products you decide to offer to your clients. In terms of the competence requirements, you'll see that if you're an FSP and rep, in terms of personal lines and commercial, you need to have advice, the giving of advice, a minimum experience of 1 year, and in terms of performing intermediary services, a minimum experience of 6 months. So those are the minimum, all right? What's interesting is that the product training doesn't apply to the key individual, but it does apply to the actual FSP and rep. But ultimately, the key individual obviously have to have training on this product because otherwise he or she won't be adequately able to manage and oversee that the reps are able to actually provide adequate advice and intermediary services in terms of the financial product. The FSP itself must ensure that the key individuals and the reps are proficient in the business training and the product training. Now, what's interesting is that this is not the responsibility that falls on the insurer or the underwriting manager in terms of these fit and proper requirements and the business training and the product training. I have to make it very clear that what these regulations stipulate is that it is the FSP's responsibility. Now, what's interesting is if you look in the legislation that both Natasha and Suzette have spoken about, there's a top-down drive. So yes, the insurer has an obligation to ensure that prior to engaging with any intermediary or any underwriting manager, both entities are proficient in terms of the product that is being sold. But at the end of the day, the responsibility lies on the FSP to ensure that it also obtains the requisite product training. So that means if an underwriting manager, not in this instance in terms of a sophisticated underwriting manager like CIB, but let's just say you were dealing with an underwriting manager that doesn't provide product training, you can't then turn around and say, they don't offer it, therefore I'm okay. It is your responsibility to then go either to the insurer or to the underwriting manager and insist on getting product training relating to that product. Because otherwise you are going to be in non-compliance with these regulations. Granted that the underwriting manager or the insurer will have its non-compliance issues, but that is separate from your obligations in terms of law. So you will see that these regulations have created what is called the product training and the business training. Now, the business training relates to your business as a whole as an FSP, right? So what this means is that, again, in keeping in line with the Financial Sector Conduct Authority Act and the Insurance Act about creating sustainability and longevity in the business, is that it's a requirement for you as an FSP to become educated and have knowledge in any aspects that could affect your business. So this is not limited only to the actual product or the type of insurance that you're offering. We're looking at things, for example, understanding how the financial sector charter affects your business, because that's something that you as a financial intermediary would have to understand in terms of your business. So it talks about things like impact of applicable legislation, and Elsa and Suzette will tell you as lawyers, that is very wide. And that's why I'm saying it could be things on POPI, it could be things on the codes, it could be things on Companies Act, anything like that. The responsibility is for you to understand how your business operates within the industry in a wider context, right? What you will see is that any representative that's working under supervision as of the 1st of April 2018 must complete this class of business training prior to the 1st of August 2019. So this is extremely important where you're taking people into your organization that are working under supervision. The good thing for all of you sitting here is that you are deemed to have complied with this because you've been operating before the 1st of April 2018. But just remember that going forward in terms of your CPD points, you will slowly have to start complying and get a fay with business and product training. So as I mentioned, then there's product training. Product training is, again, understanding the product that you're selling, the fees, the structures, the identity of the product supplier, the disclosures. So what you will see is a lot of the PPR stuff, which Natasha touched on, will be pulled into the product training in terms of a product that the underwriting manager and the insurer are offering. So that's where your responsibility is to make sure that you understand what you are selling and intermediating. And as I said, everyone needs to comply within 3 months of the 1st of May 2018. So again, if you don't understand, get in touch with your underwriting manager and ask them to explain what the product's about, what it covers, what it doesn't cover. All right. Then this is where your responsibility comes in. You now need to record when this training has been done, and it has to be done within a certain time period. You will see it's for 15 days, and you'll have to demonstrate how there was training. So it's important for you to retain your documents, all right? Because it's no use in just, when you get one of these inspections, to just say, yeah, we did training. You're going to have to show, all right? And here's the other interesting thing. which I told you about the business class training, where it becomes your responsibility, is that the product supplier, so in this instance it would be guard risk, they can actually go direct to the intermediary and say, right, part of my due diligence process in terms of onboarding an intermediary is I want to make sure that you know what's happening in the insurance industry in general. I want to see what business training you've done in your organization. Supply me with the material that you've been training your staff on. So that's why I'm saying it's very important that you take cognizance of your obligations in terms of the law. Now the CPD, you'll see that it's not applicable to a representative of a category 1, and I'm assuming that most of you would fall under this category. If you render financial services only in respect of short-term insurance personal lines. And effectively, so if you're offering personal lines and commercial, you are exempt, except where you're offering products such as marine, guarantee, or engineering. Then the CPD applies. And the reason behind it is that those are extremely technical products, and therefore you need to understand what you are selling. In certain instances, the regulator has taken a view that personal lines and commercial products tend to all be very similar and are not so technical. So just take cognizance of that. Again, as an FSP, you need to keep records of these competence registers. So in addition, if you send your staff to something like this, you would have to request that CIB provides you with the copy of the individuals that attended. You can't just assume that you allowed them to attend and they did. Then you'll see that there's CPD hours, there's a minimum, and again, it depends on what you are offering. So if you were only offering, as an example, a personal lines product, your minimum would be 6 hours per CPD cycle. But the more classes you offer, obviously the hours go up. Right. And again, compliance with this is from the 1st of June of this year. The operational ability hasn't changed substantially, except that there's now a lot more on the due diligence on the appointments of representatives. And the regs don't stipulate what that due diligence is, but the minimum must be that they need to comply with the fit and proper requirements, in addition to any other requirements that you as an organization may deem fit to apply to your organization. Right. Financial soundness, this applies obviously to the FSP and the juristic rep. This is where you need to make sure that your assets exceed your liabilities in terms of operating. You need to maintain financial resources, and then there are very specific requirements if you are collecting, holding, or receiving premiums. So there's further onerous requirements which you would need to consider. And the liquid assets that you need to hold must be greater than 4 of the 52 weeks of your annual expenditure. And if you operate within various categories, so not only in the short term, but let's say in the long term, the financial soundness requirements that are more onerous would have to be complied with. So just keep that in mind. All right, now so we've dealt with the fit and proper. We'll have a look at the binder regs. I'm not going to go too much into this because I'm sure all of you know this. So they came into effect on the 1st of January 2018 with some transitional arrangements in place. The fees are capped where you are a non-mandated intermediary that also renders advice. Okay? So you just need to keep that in mind, that it's not the insurer that's being difficult, it's legislated. So if you were to perform all the functions, entering into the policy, determining the wording, the premiums, settling claims, etc., the maximum that you can earn is 9%. If you only did, as an example, function A, then you would only be entitled to 3.5% of the gross written premium. All right. Now, you can earn more provided you get exemption from the FSCA, and only the insurer can seek that exemption. And in order to seek that exemption, the application is quite onerous because you have to justify to the regulator as to why you should earn more. And you've got to give formula. It's quite an onerous. So I don't think that there's going to be many insurers seeking exemption because it does place quite a spotlight on your business. And then it also highlights to the regulator as to why certain intermediaries are charging more than the others. But in general, we're not going to see this with personal lines or commercial lines binders, that anyone is going to be charging more than the regulated percentage. In terms of compliance, if a new binder is entered into today, it's immediate. If it was entered into after the 1st of January 2017, compliance with these regulations was within 6 months or when amended. And anything before the 1st of January 2017, you have 12 months. So effectively, by the 1st of January 2019, everybody has to be complying with these regulations. What's also important to know in terms of the binder regulations, which works closely, is the definition of associate. So you have to read the definition both in the Phase Act and in the binder regulations. And you will see that any non-mandated intermediary that is an associate of a mandated intermediary are not allowed to do business with one another. And you'll also see that the definition within the binder regulations has been widened. So it talks about if there's a significant owner within two juristic entities, or if there's a member of a governing body, then you are automatically an associate. So as an example, if I have 20% in FSP1 and then I have 15% in FSP2, the fact that all the other shareholders are not alike, we automatically associate by virtue of my shareholding. So just take cognizance of that. Likewise, if I sit on your board and then I sit on another person's board, I could be deemed to create the associate relationship. So just think about that in terms of shareholding structures and in terms of board composition. So that's where the board composition, you might not be subject to the audit committee requirements, but that's where the board composition is very important in terms of your business. And again, the juristic person definition has been expanded. So it includes things like companies, closed corporations, cooperatives, trusts, and corporate associations, partnerships. And in fact, the definition is quite wide, that it's used to encapsulate any form of possible association, sole proprietor. So just be cognizant of that. Okay, and that was me.
Thanks very much, Christine. I think we're going to move on to our Q&A session with our panel. Candice, have you got a mic at the back? Yep. So I'll open the floor up to questions. Anybody with questions? Don't be scared.
All right, just I think, Elsa, this question's for you, and it was around the poppy issue. So the protection of data, so one of the things that came to mind is that, as you know, a lot of our data is shared with our service providers, such as the roadside assist guys, our IT insurance providers. What if their systems get hacked and our clients' data gets compromised? Is there a duty on ourselves, or what is the how's that responsibility passed back to ourselves, and what, you know, how do we protect ourselves in terms of that?
Okay, I'm on. So the best way to deal with that is to make sure that your contracts with your service providers provide for all of these eventualities. So the first thing would be is to put in your agreement that your service providers warrant that they will comply with the POPI requirements, and then to also build in indemnities in terms of that agreement, to say that if the systems are hacked, if it is anything that you did, Mr. Service Provider, you will provide me with an indemnity if the policyholder or whatever then institutes an action against me. Unfortunately, it's not going to necessarily save you from the reputational damage that might be done as a result of that, but contractually you have to put in place that framework.
Any other questions?
So in terms of CPD, in terms of recording it and the training, so in actual fact we need to maybe just keep a file and showing all your product training for the year and ongoing, and then maybe proof from your from the insurer, it's confirmation that we've attended. Is that what you're saying?
So what I'm saying is that you yourself needs to keep a register. You can't just rely on, in this instance, CIB has obviously kept a register. So if your reps had attended this, you can't just rely effectively on their word. You would have to get confirmation from CIB, and then you would record on it. Part of the product training could obviously filter into the business training. And you'd have to keep those records not only because of this, but also because the insurer itself, when it does a due diligence and onboarding an intermediary, might request copies to make sure that it's dealing with a fit and proper FSP.
Thanks.
Maybe just add, I think what's quite important is that there is a requirement on an FSP to ensure that they have a training plan, and to ensure that the training with respect to the CPD, it's relevant. It contributes to the skills. It addresses needs in technical knowledge. So, there is an assessment process at the back end of that you will need to demonstrate to the regulator as well. And the CPD training plans are in the CPD cycle, which is, I think, the 1st of June, yes. Yep. That we just need to be aware
of. Just in terms of your class of business and product, so if it was before April, then you deemed to comply with the class of business. What about the product stuff? So if let's say, for example, we've been dealing with CIB for 5 years, do we then have to re-go through that, the confirmation of the product training?
Well, compliance is required from the 1st of June 2018. So if you are of the view that you understand the product 100%, then you wouldn't seek to get product training. But obviously, if you have new reps coming on board, then they would have to get product training. Either the FSP itself would have to conduct that training. So that would mean the key individuals or whoever understands the product within the FSP would need to explain it to their reps. And that's where Suzette came in about the training program. Or alternatively, you would have to request, for whatever reason, if you don't feel comfortable enough in giving that training, request the underwriting manager to just give assistance in training of that particular product. And that again would fall within your training programs. Just if the training is given by the underwriting manager, it doesn't necessarily have to be on an individual FSP basis. Part of the program of the training could be, for example, if the UMA has a once-a-year session, where it invites all its brokers, then you would get CPD points on that. But at the end of the day, the responsibility comes down to the FSP that if you don't understand what the product is about, you need to go to the underwriting manager and actually seek explanation on it. That is your responsibility. Even if the underwriting manager gives the training, they don't know what you don't understand or know. That's your responsibility.
I think what's also important to note is that the authorization clauses that we have circulated or shown on the screen on the Insurance Act and the clauses of business in terms of clause of business training is not aligned. They are largely aligned, but there are a lot of differences between the Insurance Act clauses and this clause of business training. So please be sure that when you look at your clause of business training, that you look at the clauses of business in terms of the phase fit and proper. And then there is a distinction made between what I think I call it a full rep and a rep under supervision. And just make sure that you may think as a rep that you are not under supervision, yet you are. So make sure that you check your rep registers, because if you are under supervision on the 1st of April, and maybe you think, well, I've concluded my time, but you were never formally taken off supervision, those requirements will apply to you. So it's quite important to either check on the FSB's website or talk to your compliance officer. We found in our business that some of our representatives actually approached us and they said, please check, because I'm not under supervision, I'm what just my term, a full rep. I'm a full rep. And then when we actually checked the registers, we realized that through some or other technical error, whatever it may be, that particular rep was actually under supervision. And we had to really rush to try and get them off supervision. And our compliance staff, they were really put under pressure because the requirements is really different between a full rep and a rep under supervision. So do not assume that you are not under supervision. Just double check. Check it on the FSC website, or as I said, with your compliance officer.
Just a general question in terms of compliance and compliance officers. What I'd like to know, what role will the compliance officer be playing to us as brokers in the future, where all this legislation is changing and it's onerous on us to make sure we more compliant? Is there any legislation that will hold them accountable for information not passed to us or assistance given to brokers in the future from compliance officers?
So there are certain requirements with respect to compliance officers. We know that the FSB is working on more onerous requirements. But I think what's quite important is that compliance officers do fulfill two roles. On the one hand, they fulfill the role to support the business, and they also have the responsibility to ensure that there is monitoring. And if there's a breach, they are under an obligation to report that. What is very important is that a compliance, I always say there's like a Chinese wall. So whilst the compliance officer can assist with advising and supporting, the Compliance Institute is very clear on their rules to say a compliance officer can never be a decision maker or an implementer. They are merely there to provide that supporting function. So if you do, we find it sometimes challenging in our own business where somebody would say, but Suzette, I need you to make a decision. Please tell me what is the decision with respect to a particular piece of legislation. And that is where that role is quite important, where we would say, I can advise you, I can provide you guidance, but the ultimate decision then lies with the business, with the key individual and with the CEO. And if that decision is made, whether it's in agreement with the support and the advice that's been provided by the compliance officer, and there's then a clear breach, that compliance officer is under an obligation to report. So with respect to the framework for compliance officers, what I find quite interesting is a lot of the legislation is driven towards phase compliance. And I always say compliance is so much more than merely phase compliance, specifically if we look at the new regulatory framework. And that is why when we look at the new the new compliance reports, that it's no longer called the phase annual compliance report, but it's a conduct of business report. So the regulatory framework with respect to the role of a compliance officer is also under development as the legislation progresses. But it's very important to note that your compliance officer can never be the decision maker or the implementer, or else they are not fulfilling the function for which they are employed. I hope that sort of answers the question. At this point in time, compliance officers need to pass the KI exam, and there was a deadline. I can't even remember when that was, and that's why I quickly wrote the exam before the changes. Christine, I know you want to add.
I think what's also important to understand is not to just assume because you've got a compliance officer, this now abdicates your responsibilities under legislation. The regulators are moving away from this tick box approach of regulating. So you will need to take responsibility. You will need to have a person within the organization who might not be the compliance person, but that is responsible for ensuring that, in general, the entity is complying with the regulations. Because at the end of the day, the compliance officer has an obligation in terms of law to report any non-compliance. So as Suzette mentioned, they're there to guide you, they're there to highlight issues to you, but at the end of the day, the implementation of policies and operations lies with the FSP and the individuals that manage it, be it the directors, be it the key individuals, be it management. And at the end of the day, I don't think that you can kind of say, well, because the compliance officer didn't do it, therefore I get off the hook. If you even look at from an insurer perspective, the regulators now pushing a lot of more personal liability onto the directors themselves. And the point of that is to actually ensure that there's active management and participation within the organization. So gone are the days where a director would just pitch up at a board meeting, not have considered the board pack, and just sit there and say yes or no to certain resolutions. There needs to be active participation. So as an owner or an owner-manager of your business, you need to take control. There's going to be certain instances, yes, where maybe you can push the blame onto the compliance officer, but at the end of the day, when the FSCA, removes licenses or suspends licenses, it's your license, not the compliance officer, and that affects your business.
One of the challenges as well is the move towards principal legislation. And if we look at TCF principles, what is quite difficult, whether you're a compliance officer, whether you're a legal person, is that long gone are the days with respect to rules. So in many instances, the compliance or legal fraternity would be approached to say, please give me a yes or no answer. And I want to say, sometimes I just want to cry. I do understand when I hear that, because you need to demonstrate through your behavior, through your corporate behavior, through your actions, that you are complying with the regulations. And if you have gone through a process of due consideration of the rules, and you can demonstrate why, in your view, you think this particular rule is not applicable to you, that's quite an important activity that you need to go through. But the fact that the legislation is moving towards principle-based does make it very difficult. I always compare it to a large extent to schools. When the schools move to outcome-based types of education, and they said we now need to not teach our children the rules to say thou shalt do this and you can't do that, to an outcome-based type of education framework. It was very difficult for parents and for kids to try and teach them the new outcomes-based type of education system. And we see that in the legislation as well, that it is a complete paradigm shift with respect to the rules. I must say in my mind, some of the legislation may be very boring. I'm sorry as a lawyer saying that myself, such as the PPRs, but they read quite easy. It's very easy to understand. It's written on a very basic level to unpack that. Others are not necessarily drafted in the same way. A good example is the insurance regs. If you try and make your way through the insurance regs, then it is more difficult. But you can see the way in which it's drafted and the way in which legislation includes framework with the details in the subordinates, that it does help a lot. But the role of the compliance officer, and I'm very passionate about the role of the compliance officer going forward. The role of the compliance officer is not the policeman. The role of the compliance officer is to be seen as your strategic partner, to identify the risks associated with a particular strategy in your business. And it's very important. I always say it's easier to engage with your compliance officer than the regulator knocking on your door, and for them to identify the particular risks associated with a business decision that was made. But the role of the compliance officer going forward is a very, very important role. But as I said, you know, when in our business, when I started at Guardrisk, we were called BPOs. Have you ever heard of a BPO? It's called a business prevention officer. So they said, you are the compliance officer, so you're the business prevention officer. And I stood up and I said, hey, I'm not a cost center. I'm an institutional capability. We are not business prevention officers. We are not the policemen. We are there to guide and assist you in the process. And yes, we have a monitoring role. And yes, we have a reporting role. But please involve us as you develop these strategies. And that is actually very close to my heart.
I just want to make one point in terms of the principle-based legislative framework. And the perfect example is from a TCF perspective, you've got to show how you've entrenched TCF within the culture of your organization. A compliance officer, I'm talking about an external one, I'm not talking about an internal one, would never, as an example, be able to ever demonstrate that that entity has complied, because how do you know if TCF is at the heart of that organization unless you work there? You're there every day, you're interacting with the claims person, with the underwriting person, with the receptionist. So, and that's where it comes down to that in order for you to get that compliance officer to sign off from a monitoring perspective, you're going to have to demonstrate that. Because if they're sitting off-site and they're not there 24/7, there's certain things that they will just not be able to know that is going on in your organization. And that's where I'm saying that you're going to have somebody dedicated and taking the responsibility within your organization that they can go to and can just say, well, show me, in order to ensure that you get a clean sign-off from a monitoring perspective.
Hi, ladies. Ooh, hierdie ding is baie hard. I want to ask a practical question regarding the fees. Or actually regarding the consent we as brokers need to have for charging a fee and being able to stipulate exactly what that fee is used for. And since the requirement came in, it's quite easy to now build that into your process. But my concern is about us specifically being a long existing broker and have clients that have been with us for the last 20 years. When you now try and put that process into place, it's extremely difficult to contact a couple of thousand clients and say, you know, I know you've been with me for the last 20 years, we have coffee together every Sunday, but can I please just have your consent for this fee I'm charging you, and this is what it's for? How exactly does the regulator see us putting this process into place?
Well, from a high level, a tacit consent is not gonna work with the regulator. I can tell you that if I was the regulator and you came and saw me, I would say to you what your policies and processes and how you do it is your business. I'm just telling you that you need to comply. Obviously, in terms of, you're going to have to get a form of written consent because that's specific to you. I suppose in terms of the client-broker relationship, you're going to have to rely on the strength of your relationship and to be honest with your client and to say, I need you to sign this because I need to comply with law. And I think, you should use it as the opportunity to kind of reinforce all the value-added services that you do provide to the client and that you are acting as a real broker, not somebody that just adds on a fee. I think that I think on the flip side, the conversation becomes very difficult to those brokers that have been charging a fee but do not interact with clients, don't have that personal relationship, because now how do you approach somebody and say, can I have an extra $50 every month? And it's going to highlight to the consumer that you've been charging something without actually adding any value. So unfortunate for you, I can't tell you what policy or process you need to put in place, but from a regulatory perspective, you're going to have that written consent, because in addition, if the insurer is going to assist you in collecting it, they're going to want some form of proof.
And what is the time frame again?
January 2019. So from a practical point of view, if I'm trying to think practically, I mean, as an agent of the policyholder, you interact with your policyholders specifically by providing advice. If there's a claim, you engage with the client. On renewal stage, you engage with the client. So I always say, you try and eat the elephant bit by bit. So have a process in place that as you receive a claim and you are assisting your client from that point of view to say, I'm going to use this teachable moment, this opportunity to then engage with my policyholder, whom I'm acting on behalf of. I'm going to explain this and I'm going to get that consent. Consent, when we talk about written consent, remember the Electronic Communications Act also confirms that a voice logging would also suffice. So it doesn't mean they need to sign the piece of paper, but use opportunities that you have in your current engagement with your policyholders to say, I'm going to share, for example, the main benefits of the policy to my client, and I'm going to re-engage with my client with respect to the claims process in the event of the claim, and try and leverage of existing processes to obtain that and to engage with your client so that they have a clear understanding and you will be able to demonstrate. But please don't wait too long. Because that's why we're creating these awareness. There is still time until the 1st of January. I mean, we're halfway through the year. And that requirement was in the draft for a very long time. And in actual fact, the way in which the regulators approach these new regulation and PPRs with all the various transitional periods, what I've realized is all the new stuff, they've allowed a longer lead time. So that would push these requirements into March next year or into January 2019 or end of December 2019 for the data requirements, because that stuff is all new. Anything that's current, but there's a little bit of a tweak to it, you will see those transitional requirements are much shorter periods. That's where you get the May or July type of deadlines or August deadlines. I've always said, and I know, Christine, not to punt you, but I know you've done a lot of work through some of the media with respect to when does which requirement actually kick in. I've said, if you don't have a good calendar, you better get one, so that you can keep track of which requirement will kick in at what period in time. And the fact that something's going to kick in next year doesn't mean you can wait until then. You have to start considering what these risks are. How are you going about to implement these changes. And it really is very difficult. Yesterday, I think on the long-term side, there was an announcement to say some of the rules has been delayed as well on the long-term side. And in many instances, when I get a call, the first thing I need to do is just go to the back of the PPRs and just check what is the implementation date, because there are so many dates. But then I guess it's a balance, because if they implemented everything effective 1 January, we would all be non-compliant. And the transitional periods does provide us a little bit of leeway or a little bit of grace to comply, but it does make it quite difficult, because, I mean, there's a January, there's a April, there's a May, there's a June, there's a July, and the 1st of January, and then the juristic rep additional requirements for financial soundness kick in March 2019, and then the end of 2019 is the data requirements. So it's like a lot of these key dates, and that's quite important to just be aware of it. So on the one side, yes, you need a good calendar, but on the other hand, it does allow a bit of leeway. But use existing opportunities to try and achieve that compliance.
Look, I mean, compliance should fit in with the way that you comply needs to fit in with your business model. So if you do have coffee with the client on a Sunday, create that awareness, tell him what's happening. I'm not saying go there with a piece of paper and say, now sign this, but create that awareness so that when you follow up with the email, because you're endorsing the policy or you're dealing with a claim, and you send it and you say, remember we had this discussion, are you happy? He could have verbally given you already that he's happy, but following up with the email, now you have something on record. So you've just got to tailor the way that your business operates within the compliance. And not everyone is going to have the same policies and processes in place. You've really got to tailor it for your business and your relationships.
Any other question? Okay, no more questions. Okay. Just on behalf of CIB then, I'd like to thank our panel of ladies for this morning, for your time, for your effort, for your insights into what's going on. I trust it has been very informative to the audience and the guests. And I'd just like, as a token of our appreciation, just for the ladies, just to give you something from CIB, just to say thank you very much for everything this morning. Thanks very much, ladies. And to the audience, thank you very much. Our compliance team is available if you've got any questions. I think we'll do what we can to assist where need be. Otherwise, thanks for joining us. Have a good Friday, drive safe, and have a good weekend. Thanks very much.